Okay, we are back on the record. We've basically completed our, for the most part, we've sort of mapped out our scheduling of the applicants and general framework for interviewing questions. So I think now we want to sort of move into the scope of work and the cost questions as well. So it's a good topic to get into. So maybe, Commissioner Dodge, again, just remind us, what do we have to work with again? I'm blanking on the numbers for some reason. Was it 300,000?
Well, it's been modified and lumped together now with the technical consultant. So,
that's right. Oh, the technical consultant.
Yeah, so those two contracts have been put into a single line item now.
Oh, okay.
But I can tell you that together for the first fiscal year, for both of them, it's 500,000 approximately, a little bit more than that.
So that's through June 30th, right?
We have how much?
This is how much we've budgeted. Doesn't mean we'll be granted it.
Right.
But it's 513,000. I'm sure there's a reason for the odd dollars. Yeah. But yeah, I just checked it. The latest version I saw, and it includes both the line drawing consultant and the VRA attorney. So these are the contracts.
And experts.
Actually, technical experts is a separate line item.
Okay. And
there's no guarantee we're going to get this money, and so regardless of, I mean, I think that's just good as a ceiling, but the ceiling may actually be lower. So whoever we end up working with, we're going to be, working very closely with Mr. Miller to contain costs throughout the whole process.
Okay. And do you have figures for fiscal year 11-12?
Yes. That's 371,000, a little bit less than that. Again, I'm sure there's a logic for exactly how those numbers came out, but again, includes both the line drawer and the VRA attorney, and that's even less likely that we'll get. So we just need to be clear, and this might be something that we would have to put as a clause in whatever contract we write up, because there needs to be some kind of contingency if the legislature doesn't approve our budget request, and or if they approve it, but the budget isn't passed on time. So there might be a long payment period. Right. So there's some considerations there, and then we need to think about, this includes the line drawing piece, and that's the piece we're really going to need. So
best case scenario, assuming again approval and budget, the full budget is approved, we've got a little bit under 900,000 to take us through basically August 15th for the attorney and the line drawer, right?
Again, we don't got anything.
No,
this is what we're requesting.
Right. This is the best case scenario. I mean, it could be considerably less, but that's kind of the upper limit on what we might have to work with.
Yeah, and if you look at the bids, we have several bids that should put us well under that and within the range. So I think we're okay, but in material of particular applicants' proposals, I think that we I think what the full commission is expecting from the Legal Advisory Committee is, some idea of how much time we're really going to need. And then, like I said, you can negotiate on the hourly, or whether it's structured as a fixed fee or whatever. But we can do the math in whatever ways. But we saw some proposals where pieces of work were walled off and said that this bid doesn't include that, and that's going to be bid on an hourly rate. So I mean, that, as has been pointed out, could really drive up the cost. So I think what I was hoping the advisory committee would discuss is to get some clarity around what we think we are going to need. It's like, what are we buying? As you said, what do we know we need to buy here? What does it include, so that can be negotiated in any upfront contract that, with our preferred vendor here.
Just a question. At the last commission meeting, did we decide on sort of a bare bones budget if we didn't get any of the augmentation? Didn't we come up with a number? Like $3 million through.
This is a stripped down budget, and most of this is adjustments in terms of our outreach efforts. So I think that Mr. Claypool, we would hope he did, protected most of the consultant money, so that we haven't stripped out of our budget. But the reality is that we can't really expect more than the $3.5 million that was in the original allocation. We can ask for it, but there's no guarantee that we'll get it. But I think what we need to focus on is what we think we need, and based on what I've seen of the four firms, I think we can get in that range. So I'm not too worried about the upper end, but I think we just need to be more specific about what we're going to need and how much time we think that's going to take. And otherwise, everybody, like I said, has a different set of assumptions on what they're providing us. So we need to be clear what we want.
So the question, and I'll go to Commissioner Ward in a sec. So do you recall what the initial line item was for the technical consultant prior to consolidation? Was it?
Yeah, I think we used a number of $750,000.
$750,000, okay. Which I'm assuming.
Which was just a guess, right? I mean, we haven't seen any of those bids yet. That was a kind of a midpoint between the highest number we heard and the smallest number we heard.
I just want to get some ballpark figures so we get a sense of how the $900,000 ought to be split, roughly. And you're right, $900,000 is optimistic, of course, but to get some ballpark figures.
Well, I remember in tracking the proposals that had a hourly rate, and then those that listed out their hours, and it seemed like the spread was 500 to 800 hours was what I had written down from the proposals, from what the vendors were suggesting. No, the lawyers were suggesting how many hours that would plan on needing to complete the commission's work on their end. So I don't know if I didn't write down the spread from lowest to highest as far as hourly rate from what was offered.
Okay.
I wrote down some of that. I think the low was, well, and again, there are different levels of staff. I think the low was like $75 an hour for a paralegal, and then for experienced attorneys, I think the low was in the $250 per hour range to, I think the high in this group was 500 of the four firms that are still left in the running. So like I said, we can do the math. So the question is, do we think the hours are going to be comparable?
What was the junior attorney rate?
I think 250, I think was the low.
For junior. And we did have a number of discounted down to 250.
Yeah, that was from Munger Tolls.
Was it Munger Tolls that did that? Did Gibson do that? No, Gibson didn't do that. That's right. Gibson didn't get that specific.
Question for Gibson.
Right.
Maybe lower rate for associates.
Okay.
Yeah, I think Nielsen was 500 an hour based on their assumptions.
Let's see if they.
Oh, yeah. The Gibson wouldn't give us the number.
Right.
That was their issue.
And then we got some ballpark numbers without a specifically hourly rate. So I'm sure there's an implicit hourly rate in there.
Should we list them?
But didn't both Miller and the other woman, her name's escaping right now, didn't they both say it would be about 200,000?
They said it would not exceed that, and it should be a lot less, is what they said. And it would have to be less.
That's right, Gilda Daniels.
But I think, back to Commissioner Ward's question about whether they need to be at public input hearings, I think that's a really valid question, because I could imagine they would need to be present as we're drawing the lines and making decisions, but when we're just hearing things, it's not clear to me we need an attorney to jump up and respond to every random comment,
I think that's a very good point. I think certainly when we're making some decisions about where to draw the lines, I think that we need that attorney in the room. But when we're just doing straight input, and as I've suggested at previous meetings, I think we do have to try to allocate some special meetings for groups that may be presenting statewide maps, including some that will be presenting probably some Section 2 and Section 5 related maps. So
then they may
For
have to
those
be at
partic-
certain
Right.
meetings.
For certain meetings, I think it might
Right.
be possible. But I think for the general public, even though it may come up, suggestion, well, here we are in Monterey, and
Right,
Monterey
maybe in
County-
the 4
right.
counties,
For
you
Section
know.
5, it might be specific, but I think it's a correct assumption that for the bulk of the more general public hearings, that an attorney wouldn't be essential to have at the hearing to sort of spot things. We can try to have both staff and commissioners sort of be on the lookout for those and then flag them. And then, again, we will have transcripts and other devices to capture that too. But I think it's a very good point that we don't have to try to allocate all the time for input hearings. But certainly, the business meetings where we're making decisions, if there are, again, maybe targeted the next round of input where we're presenting draft maps and there's some remarks, and if we have, again, Section 5 counties or other ones where we are in particular raising questions about Section 2, it's appropriate to have the council there.
So are we talking about then at minimum 9 public meetings, right? 4 at the county, 1 community group map input session, and then I would imagine at minimum 4 line drawing commission sessions. That puts us at a minimum of 9. Which is quite a bit. Which is quite a bit.
Well, the question is, our line drawing sessions, how long are those going to be?
Yeah, I mean, they may be 10 days.
Well, right. So, like I said, 4 is a small
Minimum,
number for
yeah,
that.
as a
So
minimum, yeah.
We're actually talking about quite a bit of business meetings,
Yeah, I think so.
which
Yeah.
is
Which is why none of them committed to include that, because they didn't know how many dates we're talking about. But, I mean, that's a question we ask about capacity and availability, too. It's like, if we're going to, I mean, the last I got from our input sessions that we had here in the Capitol on Saturdays that, you know, that we may have a very intense period of, 5 to 10 days where we're just sitting there sequestered drawing maps and figuring it all out and, acting on all the public input, which we've been listening to all this time.
And I think it's possible, certainly, during those marathon sessions to, divide up parts of the state or say, well, probably, I mean, not making any assumption, maybe that the most northern counties, we're not going to be dealing with the same issues that we might be dealing with in Los Angeles County, for example. And the council wouldn't have to be at some of those meetings. But obviously, there are plenty of areas within the state where they need to be there.
Well, it strikes me that what we're saying is that as we do our regional meetings, we don't necessarily need the VRA attorney, but we do need them when we get for these marathon sessions. Now, given the number of days we're going to be out and about, you have to assume there's 30 days taken up in these, I'll call it outreach meetings for lack of a better term. We have 4 months. We have April, May, June, and July. So you got 120 days, 30 of which are taken up by these outreach meetings because it's 90 days more. The question is how much of those 90 days are we going to be spending actually sitting down drawing maps? My guess is we're going to do it 2 weeks a month, actually just drawing.
Thanks.
I mean that's just a guess. But if I have to sit here and pick a number, I think we're looking at 6 weeks of line drawing because we're not going to do it in April. I mean, we're not because we're going to be out getting input in April. But I don't know that we're going to put pen to paper, so to speak, until May. That's just an assumption, but I'm open to anybody else have any ideas. I'm just going off the top of my head on how long we're actually going to sit in these marathon sessions. Right. But I think, I certainly am mentally allowing 2 weeks a month. And so, that's a scope, but other people can have different numbers. But it's
a good place to start.
I thought it was sort of blanche when I said that.
Yeah.
maybe ahead of. Oh, sorry, Kirk.
Well, just marginally helpful to your point, we do have a calendar to present, a draft calendar at this meeting. Let us double check how many business meetings are planned for May. That would help a little bit on your estimate. Than the number of May meetings where that would be a possibility.
And then I think the question we have to ask ourselves, at these actual line drawing meetings, where we're working as more or less the committee of the whole, do we want the voting rights attorney to be there at our shoulder while we're doing this? I mean, is there a straight one-to-one correlation between the time we're there and the time they're there?
I
I'm open
was
to
going to
that.
ask.
That's just a question.
I was hoping that the experienced, attorneys on the panel here would provide me some definition with that too. This model is definitely different than what I just had kind of comprehended without having that experience, and that is that we would, as a commission, with technical assistance and technical input, make decisions on where we wanted lines, and then submit that for VRA legal review. Not have that at the ready, only because, again, that model kind of gave me the impression of almost being steered by, so as these questions come up, getting an immediate legal, read, and then making an immediate decision on what we want to do with the line. My thought was that as a commission, we take all that technical input, we take, all the legal criteria, apply that as a commission to a map, and then we submit that with our justifications for that to VRA for review. And then at that point, they can provide options or they see problems. I didn't necessarily see the VRA lawyer, and again, this is, excuse my lack of experience with it, being at the meeting, at the ready, making game time decisions on our calls,
I guess my only concern, I mean, I have no more experience in this than you do, Commissioner Ward. I don't think I've done this before. I'm concerned, again, it's a time issue, to go out with a set of maps, ask them to comment, then the process comes back, and you wait a few days, and you go back out to them. I think that's why I don't think that's going to be the model. I could easily be wrong on that, but I think it's going to be much more back and forth over the map kind of discussion, because we're going to say, well, we want to move these 5 census blocks out, and we want to bring these over here, and I don't want to have to wait 3 days to find out that couldn't do that. Because the voter rights access attorney says, you can't do that, bad call. I mean, I think they're going to have to be pretty close, with us to let's move stuff around.
Can I suggest that we tackle, sorry.
Go, no, go ahead, please.
No, I'm just,
Too much stuff.
potentially try and tackle this not from a calendar yet perspective in meetings, but the things we expect the attorney to do. Okay.
Let's stick with scope.
So,
Well, I think what we're trying to do is determine scope by determining if, in fact, we need to be considering how many public meetings, if any, we want these people at.
right.
That's,
But I was just thinking. Let me just say what I was thinking. Maybe this helps or not, or doesn't help. So, and I have a little bit of a cheat sheet here, so that but there are going to be some Section 5 counties that we have, that there's going to be initial work that has to happen to review the submissions from 2000, and then all the sort of baseline or whatever the terminology is. I can't remember right now. I've never really done a lot of Section 5. And so there'll be review of documents that this attorney, only the attorney, really can do for all the Section 5 from counties, both looking at their past things, the pre-clearances, what happened with them, and setting the standards. So that there's review of materials there. That's a task. I think that with or without the map drawer or technical assistant, which is a better term, the attorney's going to have to get completely familiar with the census data, where the population growth is, what the demographics of that population growth are, and be prepared to tell us, not just the technical expert, but prepared to tell us, here are the areas where you have loss of population, and therefore, in order to reapportion, you're going to have to you have to do something potentially here because of loss of population here, in different parts. So they should identify for us, since we don't have a demographer on staff, the attorney's going to have to identify for us those areas where we see the population shifts. And then I would say that attorneys should look at that in combination with the demographic, racial, ethnic makeup of those shifts to already begin to make some kind of give us some sort of informed analysis of what the makeup of that population that's shifted and the one that's left and what that means. So those are all things that, the reason I was trying to do it, that have nothing to do with the public hearings. Those are just tasks that they have to do.
It's analytical beforehand.
Yeah, beforehand. And that'll require a lot of, this is what they have to do almost immediately the day they start, because the data's all there. And I think they have to begin to look, in that analysis, they have to begin to look at the application of the line of cases we've been discussing. All the Section 2 cases. They have to begin to work with our criteria to begin to see how it plays out. And potentially give us a legal analysis of what they see is in store for us and for the technical consultant. So I think that's one
chunk
bucket of work.
And I would almost see them providing us, kind of a range, if you will, of where it would be, safe to draw lines kind of in this range. Here's where you would run into trouble. And then we would decide exactly where the line should be. But I would imagine that through that analysis that they could provide some guidance up front before we even do anything.
Now, if that's a bucket, in order to get to the point where they can apply the criteria well, they're going to have information about communities that's not in the data, which is the community of interest input from our hearings. They're going to have discussions that they hear about neighborhoods, because that's in that in Prop 20, and probably information that'll come up at the hearings about why it's almost community of interest, but it's not, but why people think their cities and counties should remain whole. That kind of information will be part of what they have to use for their analysis. Now, the question is, do they have to be there? That's what they are going to need to work with that information along with census data. But the question is, do they need to be there, let's say in that first round? Let's just talk first round, when people present that to us. So that's one, how I would sort of formulate that question, and maybe we can talk about that. Like, given that that's what they'll be doing, do they need to be at that first set of input meetings? What do people think?
Well, in terms of cost, I would say no. I would think it would be more cost effective if they simply read the transcripts, because there's an awful lot of downtime in a meeting that we're paying X hundreds of dollars an hour for. And transcripts, they'll at least get the meat out.
Well, and actually, as I understand, it's going to be our map drawers' responsibility to gather the input from all this public hearing and summarize it.
Right.
And use that information to put into the map. So that seems to me that interface will be important.
Yeah, because I mean, going back one step, I think it's important in terms of just the voting rights attorney, and if you have the statistical consultant, not the line drawing consultant, on board, that they very upfront give us a lot of, this could be various memos and various guidelines that we should follow as we're doing the input hearings, and just things to watch out for. And when we catch them, we note them, and of course, sort of highlight them in the transcripts as well. And they will be compiled by the technical consultant, but we can sort of highlight some of those for the attorney, so that, and we may want to do it by region, or rather than dumping it all at the same time at the end, but to have sort of a rolling set of data that we can provide to the consultant. So they don't have to actually, the attorney, so they don't have to be there, but they're getting the information on a regular basis.
And it's also going to be, we're hoping there's going to be information brought to us not through the meetings. Through email.
Right, absolutely.
And so to have the attorney focus on just the meetings,
right,
especially.
Exactly.
That needs their time to get all the universes of information.
Yeah, and that's a data, that's a we as a commission have to think through all of
Right.
the various inputs.
That's right.
And where it's all going to be put.
Right.
Yeah.
And input it into the database as well. Yeah.
So maybe we know that for that first set of meetings, different question for the technical consultant, but
Right,
for the attorney,
Yeah.
that first, how many are we talking about?
9?
9.
They don't have to be,
Not the best use of
Yeah.
their time.
Yeah.
like you say, they may have to help us, help prepare us for those
Right,
meetings. by
exactly,
a little bit of a
right,
exactly.
Toolkit type thing,
Right.
Exactly.
but they don't have to be there.
How do you feel? Feel
Yeah?
free? Okay.
Oh,
Great.
Okay.
Making progress. This is good.
Well, and keep in mind that Mr. Miller will also be at a good number of our meetings, so,
Right.
I mean, he's an interface, our technical map drawer is going to be an interface. I mean, I think we really need to think about when we're going to need their expertise, and also, are they going to be prepared to do it in a real-time fashion anyway? I mean, I would think, for example, if we're going to get maps, several groups told us they're going to be submitting regional maps or entire maps for the state, and I would think they would want time to study that and review it and not have to respond in a public hearing right on the spot. I mean, I wouldn't think that would be
Right.
ideal.
Right.
So,
Well, as we're getting close, let's say we've got the inputting, we're getting various sources of inputting, and we're getting down to it's time to go to the marathon sessions, right? Now, would we want the VRA attorney to basically, okay, before you go into your marathon sessions, here's stuff you need to think about as you're actually drawing the maps, versus what may have been given us up front in terms of input, or would we have already sort of gotten all that stuff up front? In other words, we don't have to have the VRA attorney back in to say, or to remind us, here's what to look for as you're actually drawing the maps. Or do we want them back in at that point to say, hey, here's stuff to look out for as you start drawing?
I think before that, there's another big bucket of work, which is the attorney with the technical consultant.
Correct.
I think
Right,
they're going
right.
to
They're
do
gonna be
a
talking to each other.
tremendous amount of work
Right.
together, because that technical consultant is going to be constantly talking to the attorney
Right.
about this, that, blah,
And I think that's a
blah,
back and
right.
forth. It's
Yeah,
gonna
no,
happen.
that's what I mean. It's
And
a
it
back-
doesn't have
so
to
that
be with
doesn't
us.
have to be
Right,
with us.
right,
So they're
exactly.
going to they're a team,
Yeah,
and they're talking.
I agree.
And so when we get something that they, as a team,
Have decided it's a good
have to,
thing.
that's worth presenting to us, and then we, eventually we'll present it also to the public. We probably do want the attorney at the meeting, because they will have been part of the team that presented this and put it together. So I think we do need them at the meetings where we're looking at something that's been put together, together with a technical consultant. Simultaneously, they need to be looking at the maps that the public submits.
Any whole maps.
Any whole maps.
Whole maps, okay.
Yeah, they have to be looking at whole maps that may be submitted. They have to be looking at them to see how they compare,
problems.
if there are problems, how they compare to, maybe they resolve an issue that we've been looking at, but they do need to look at what's submitted, so it's with a legal eye.
Let's think about that for a second.
Okay, let's think about that.
It's just sort of trying to think or predict how many of those sort of big statewide maps we're going to get. And we know.
Small number.
Well, the problem is because it's not too hard to draw statewide maps, actually, anymore, at least at some level. For example, it's not too hard for a member of the general public to draw a statewide congressional map. I don't think there's a lot of public software. The numbers are there. It's not hard. So, which doesn't mean we're going to get a lot of them, but it's a lot easier than it used to be to do that. So, one question I would raise, and again, maybe I'm just worrying about something that's not going to be an issue, but we know that there are some major players, certainly the parties and the civil rights organizations that we've been hearing from will be submitting maps. We know they're coming in. We know that, and those need to be looked at carefully, obviously. I'm just wondering, in terms of the volume of other sorts of either statewide or regional maps, if we think we might have a lot, or again,
I don't know, but again, I see that as the line drawing consultant's job to summarize all of that, because
It's just a question of whether, again, if we get a lot, do we want to put them all give them all to the Voting Rights Act attorney?
No, I would give them to our technical map
Technical
consultant.
Okay. Yeah. Okay. Because I was sort of hearing you might want to give that to the attorney.
After the technical map
Is this a sort of
drawing has
condensed thing?
summarized
Okay.
them and
That's fine.
come up
That's
with
fine.
specific questions.
That's fine. I wasn't clear on that point. That's
Yeah,
fine.
because that would be disastrous. That would just
Right.
take an infinite amount of time,
Right. Okay.
potentially.
want clarity on that point. I was sort of getting that. I didn't think that would be right. Okay.
Yeah, I mean, my understanding, I mean, that's the reason the lines part of the budget is devoted for that effort, because it's not just drawing the lines.
That's right.
It's actually categorizing the input and saying how many people said the same thing, and capturing all that data that goes into drawing the lines. Then that's the job of the line drawing consultant.
That's right.
And that's not what the attorney should not have to look through, 1,000 maps. That
Right.
should not be, just as we should not have to look through 1,000 maps. We need to review the summary of it.
Right, so when we have the other bucket of work, which is working with the technical consultant to eventually present us with options, that includes that the technical consultant has
Already done all this.
gathered some information and they put, they work together with that input and, to present us with things.
Commissioner Ward, go ahead.
Oh, thank you. So this is a little bit of a shift from what I think I heard us initially outlaying as a process for drawing the lines with the VAR attorney. What I understand now is we're talking about the VAR attorney collaborating with the technical advisor, receiving summary inputs of maps, comments, things like that, testimony received, and then them preparing a option list, a legal read and option list for contentious districts, and then we, at that point, draw a line based off of that input, whereas before we were talking about sitting down, doing that as a commission, taking that input, taking all that stuff, coming up with our own maps, and then submitting those to the attorney for review. So in other words, it seems to me like there's a difference here, what we're talking about between the commission taking data and drawing maps, and us providing information to a technical advisor and a voting rights attorney, and then having them tell us how we can draw our lines. And it seems like two different concepts here that we're talking about.
Yeah.
Can I say something about that?
Go ahead.
I know we've kind of talked about this as perhaps a philosophical or whatever difference on the commission, that some people think we should be drawing the maps, and some people think the technical expert and the lawyer should be drawing the maps and presenting them to us. I really don't see that as a neat distinction. I think it's partly a false dichotomy. I think that we will get presented with analysis of, like I said, about the population growth and where it looks and where it has to happen, where the shifts, where the lines might have to, because they have to be drawn in that first round. I think when the lawyer is working with the technical consultant and then comes to us, and then we talk to them, we are drawing the maps.
Yeah.
I don't think it's like they come, they draw the maps, and then we look at them and go, I mean, that might be what it feels like, but then we look at them and we go back at them, and then they come. So I don't think it's this thing of we're not drawing, that if we're not sitting there doing the first map, then we're not the map drawers. I just don't see it such a stark difference between the two roles. I actually think it's a collaborative process that has a lot of, having watched this in the past, it's not that clear cut that somebody just presents you with a map, or you present them with the map and say, say to the lawyer, give me your opinion of the map.
Right. Well, I think, and again, I think the full commission should talk about this more fully, because there are some philosophical differences, and I've made a secret of I feel that the commission should play a stronger role if you're shading in one direction or the other. But I think in particular with what we're concerned about with this set of issues, that I would like initial guidance from the attorney, particularly on Section 5 counties, in terms of making sure we're not retrogressing and we're complying with Section 5, and that there are, again, general trends that all of us will be kind of aware of where the growth is. It's not a secret in any kind of way, but I like some sort of reinforcement from the attorney and the consultant. These are things you ought to be looking at, and again, whether I prefer, in terms of before any maps are drawn, that we say, okay, do this, as opposed to give us a draft and we'll comment on it. That's my shading on this philosophical difference. But I think, again, with this particular set of issues, I certainly want a lot of guidance saying, okay, here's what you need to watch out for. Now, tell us what you want, if you're going to do it that way, or if you're going to say, well, okay, you guys draw some first ones and we'll comment, at least tell us what you're going to be doing, and we'll just say whether we agree with it or not, and here's changes we would recommend. So even if there's a philosophical difference, there's, I think, a lot of guidance that I would want on these particular issues, because, again, they're very specific.
So I'm an engineer. So this is, this is simply understanding what our constraints are. We have a problem to solve. It's just a simple math problem. It's a very complex math problem. There are boundary conditions. We're bounded by the shape of the state. There are other boundary conditions, and that includes the Voting Rights Act. And what does that mean? That's why I was saying maybe they would be telling us, here you can draw lines in this range, and if you go out of that range, you're going to get into trouble, right? So, I really see them as telling us what the constraints are and how much flexibility we have, and then we as a commission will say, okay, we want to grow, we want to go north, or we would like to get it to be fatter. That's the kind of guidance we'll provide, and then they'll go away and they will try to come up with a map that adheres to what objectives we've given them, that also comply with the law. I mean, I think that's how it's going to be. And so really they're just helping to help us understand what the constraints are. And we will have all that latitude within those spaces to draw the lines exactly this way, or go around the census tract and include that one, and whatever. Those kinds of decisions we will make, but we want to make sure that they're going to be legally compliant.
So for purposes of this discussion, I think, so we have the work with the technical consultant. Then I think that this, it's your approach, which is much more like we say we want this and people come back, or whether, whatever the spectrum is there, that there is essentially a very intense period where we work together, where there's a back and forth, whatever, or wherever it starts. There's an intense period of back and forth between, the consultants, the technical consultants, the lawyers, and the attorneys, literally, sitting there looking at stuff, and if we did this because we want to keep this county, what happened, all of that stuff has to really happen with
in
real-time conversation. And so I think there will be several sessions like that, because you'll have, so if we think of a timeline, we will have a session like that when we take out what is hopefully already a pretty decent first map out to the public. We'll come out of a process like that with the technical consultant and the lawyer. Then we'll go out, we'll get input, and then we'll have to have another one of those sessions as a team to see what people have said. And perhaps even they're said, including maps that we've received. Right. And then we'll have to go out and, have intense, and then go out again and have that last sort of round of the team working. So that's how I see it, that there are three sort of periods at which we have to work intensively with the technical assistant and the lawyer as a team to produce something, and then go out and get input, adjust it with the team, go out, get adjustment with the team, and go out finally. So I would say that if you want to try and enumerate what that means in terms of days, it probably means, if you were conservative, you could say 2 days for the first round, 2 days for the second round, 2 days for the third. That does not mean that they're not working in between with the technical and doing legal research and all of that. So at least 6, let's say 8 meetings where we're working, as a team.
8 days.
8 days.
8 days. 8 days, completely intense. That's all the business that we're conducting.
Right.
And then, so I would add that to the 9.
Public hearings.
We're not putting them in the public hearings.
The two sets of when we take the maps back out the public.
So we have 9 days that we know they're not doing this other bucket of work, which is doing their analysis.
Right.
9 days of meetings with us. And then I think we have to decide, is that, do we send them out to other meetings? And how much, are we forgetting a big bucket of this work that's not in a meeting? You know, they have to prepare, the other bucket is they have to prepare the report that accompanies the map. They have to draft that report, and that will be in consultation also with the technical consultant. So that's a big chunk of time too, the report.
Well, when you say the report, are you talking about
The report that
Final
has to
report.
that has to accompany the
With the
submission
maps.
of the maps for certification. And that's a big task. It's actually a big chunk of time, report preparation.
Mr. Ward, do you want to?
Thanks. Yeah, you know, trying to wrap our heads around this. I wasn't a part of the putting together the bid, and one thing I'm wondering is if we approach this from a strictly hours, just instead of trying to figure out how many meetings and
Yeah,
how long it's
right.
going to take it, and just tried to say this is what we want to pay an hour, and this is our estimation on how many hours we expect the job's going to take. The thing that, to me, that seems to have precluded that is in the bid, we separated out public meetings as something special. Is there, I'm
I
wondering,
think
since I wasn't a part of that process, if there's a special reason why that had to be done, and if at this point we could just, like I said, being that there is so much of this that we're kind of having to invent as a small panel, if we could just go ahead and come up with a estimation of total hours it's going to take to include potential public meetings, no matter what form those hours take. This is what we expect hours, and here's what we're budgeting per hour for each of those. And then that will allow us the flexibility in being able to sort this out as we determine who our technical committee is and so on and so forth.
Well, that's kind of where I'm headed. You know, if we have these,
Right.
the bucket of reviewing data, blah, 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 the first one, then with the consultant, then the working with us in whatever many meetings with full commission, and then the final report, that then we try and look at those 4 buckets of work and try and attach hours.
Well, and
to
this
that.
is where I would expect my, the consultants that I'm hiring to be the ones who are able to estimate those hours the best. I just want to make sure that we know what the buckets are,
Right.
but they should be the ones who'd say, yeah, we can do that in, we can do that in 50 hours, in this month, and whatever, and this is the multiplier we're going to use.
Well, and we asked for that, and my curiosity is that, again, having not been a part of the discussion, that's why I'm asking the question, is why the panel chose to separate out business meetings as a separate item from that. Again, just being a observer, it
Was
seems
it
like this would
separated
be
out? I
much
know that it was-
easier to do if we just simply came up with a total hours, can agree on a,
Well, as I recall, I think the reason there was any sort of separation now was simply we wanted to get a sense from the applicants that they could be at the meetings, and that those were hours. And certainly you could do it some total of hours, including those meetings, but we wanted to make, because a lot of work can be done at the office or remotely or over the telephone, but public meeting, you need to be at the public meeting. So I think we were trying to gauge commitment to being able to attend the meetings more than just sort of the hours. And even then, as you know, there's some variations on how long they were estimating the meetings would be. So I think, as I recall, I think that was sort of the reasoning, wasn't it, in terms of...
Well, we really didn't have a feel for how many meetings we'd be asking the lawyers to attend, and the only way to get an estimate that way is on a per diem basis, essentially, and you multiply it. And even now, we're uncertain about how many. Although I do think it's a very prudent choice to eliminate them from certain of the outreach meetings. Now, the pre-clearance districts, maybe you want to do it differently. Maybe we can limit time by having the lawyers only at a portion of our long meetings, but then it limits to some extent the commission's flexibility On the other hand, it's something of a luxury to have them available for 12 hours.
Right.
You know, 6 of which they're working on their BlackBerries. So they're good but hard choices.
I mean, it seems to me for like I guess I'm trying to say for the purpose of this meeting, we're just trying to come up with, figuring out how many hours and what the budget's going to be on this, right? What it is we're spelled out the scope of what we're asking them to do, and we line item that out at a different expense. You know what I mean? And so at this point, being that that's going to evolve and change, and we don't know, right now. Can we just, like I said, try to come up with a guesstimation of hours, a fare per hour, and
Let me come at it this way. Let me make just as playing with the numbers a little bit. We had two individuals give us a bid of roughly $200,000 each. At $250 an hour, that buys you 800 hours of time.
At how much an hour?
$250 an hour,
Okay.
if my math is correct. Now, it seems to me that 800 hours in 4 months should be adequate. I mean, that's maybe I'm wrong, but it seems like, that's 200, what is that? It's 200 hours a month. That's a lot. $250 an hour. So, and I said only to give you some perspective on what they're expected to be paid, how much time, in my mind, they're prepared to commit to this, or they ought to be.
Again?
Well, it's...
No, I'm just...
800 to 250.
It's 800 to 250 is 200,000.
Okay.
And maybe 250 is the wrong number, but 800 hours is a lot of hours.
Well, and both of them said that they expect to be significantly under that, and I think they would have to be because there are only so many hours in a day.
So, exactly. 200 hours. They're not going to do 200 hours a month.
Yeah, and the other issue, and given that the other estimates were more like 50 or 60 hours a month, so that's what I was saying. There's a pretty substantial difference in the estimation of hours, and in the end, we don't care because we care what the product of that is. So, if they want to have a $500 an hour, that's fine as long as we get it under budget. So, all I want this committee to consider and have a clear idea before you go into these interviews is do you know what you're getting for what they're proposing, and is it going to meet the needs of the commission? If they want to propose a different hourly rate or a different number of hours, as long as the product comes out within our budget, I'm fine with that.
So,
No, go ahead, 'cause I think
I think this is what we're getting there. Would you recommend that, or do you think it's totally not useful for us to set a not to exceed number, or do you think again you care about the product and we shouldn't?
Well, I think there's an implicit not to exceed number based on the budget that we submitted.
I think a not to exceed number is good, and I think that I look at this $200,000, and to me that's a generous not to exceed number. To get to August 1st or August 15th.
What was Gibson Dunn's rate? 250.
Munger Tolls had the 250.
That's one of the problems.
Gibson,
The implied not to exceed, just for those of you who haven't done the math here, the implied not to exceed is about 150,000.
That's but that's 600
Which,
hours.
like I said, based on the proposals we've seen and the hours proposed, I think we can be comfortably within that.
Yeah, I do too.
But like I said, I mostly want you guys to be clear about the buckets of the kind of work and then what's actually included in the proposal that we got, since we have certain proposals that excluded large chunks of work.
Let me raise
Are there
that.
numbers?
We haven't talked about that in terms of, to use the phrase, buckets. And I say this about what was not included in their bill when they said that legal services specified do not contemplate advice and assistance concerning a pre-clearance submission. Are we going to need a pre-clearance submission that we're going to pay for?
That's right.
I believe that typically occurs after the maps are drawn, and since we asked them to estimate this through August 15th, I think that's the reason why it wouldn't be covered.
I just wonder whose nickel is it on?
Well, we would be paying for everything,
Okay,
of course.
because our budget contemplates we're going to pay for that. Is in the $150,000, I think. Is that what you're saying? So I think that's a bucket that will have to be filled.
Well,
Has the Secretary, no, I take that back. Well, the Secretary of State has been submitting the pre-clearance requests on Prop 11 and Prop 20. Is that correct?
I don't know the answer. Do you know the answer?
And then
Because they've been we haven't submitted them, right? Because they've gone forward, and that is a separate cost. Certainly, we could have this council do it, or if we can again turn to the state agency that's been doing on the other items. It's not that extensive in terms of what you're actually submitting to the Justice Department. Actually, it's actually just a letter. It has to be a carefully written letter, but it's a letter. It's more important that you have, in fact, satisfied yourself that you are satisfying Section 5, which is what this attorney would do. But the actual clearance letter, I think, is, again, we could build it in. We could have, again, whatever state agency has done in the past do it.
Again, I don't want to debate all these little items. I just want you guys to be clear what they are.
Yeah. Well, and I'm looking at Maria's notes. I see numbered items, but
See, I'm not that disorganized.
and the one thing I wanted to add, and I mean, it was sort of mentioned, but I think there's actually a fair amount of upfront legal research that I would like to see on some of the questions that I will ask on Thursday, which will be around the appropriate population, small, sub-majority minority districts, coalitions, those kinds of things, where the law is kind of gray, and I'd at least like some confirmation that if we're going to move into some gray areas, we're moving into gray areas, and when there's clarity, there's clarity, and so I think there's a fair amount of time that we'll need, because those are not, frankly, those are not well-developed areas of the law right now, and I certainly want at least an opinion that will guide the commission in terms of where we're going. So I would add that sort of to the very first set of tasks that the attorney would want to work on.
And I'm looking at all the applications except for Gibson Dunn. Let's say we know our not, like you say, our implicit not to exceed budget, not to exceed number is 150,000 because that's what's in our budget. But we know there's, give or take there. But if we have made the decision, I was going to say if we've made the decision that the input meetings are not part of this work, I was going to say that everybody kind of falls somewhat, all of our applicants fall somewhat within that range, except that I am worried about the attendance at our business meetings being perhaps billed separately by Leone's firm, and the legal analysis of the polarization.
Right, I was going to ask that.
And those could potentially kick them not over our not to exceed implicit budget, but take them a little bit out of line. And those are big buts, right? But other than that, everybody's kind of coming in at this $200,000 range with some with guarantees. So I say all that to say that I think it's true that once we clarify that with Leone, that really what we need to do is clarify what we want from this attorney. And I do think it would be good to ask them for an estimate of hours in the interview. In other words, even if it's by introducing that question by saying, here's how we see the buckets of work that we see you'll have to do with us. Given that, what's your estimate?
Well, and
hours, but-
this was the reasoning behind my suggestion to ask a question about methodology and work plan, because if they bid on this, they have to have an idea of how they're going to approach it, and they had some implicit assumptions in coming up with their hourly estimate to for those who came up with a fixed monthly fee and all that. So they have an idea. I just want to make sure that you guys have an idea and that you extract that from them in the interview, so that you're clear what you're getting from each one, because it may not be a totally apples to apples kind of comparison, and you just need to be clear what's included in their assumptions and numbers so that we don't get any surprises later on down the road when we're actually, looking at their monthly bills.
So, I'm looking at Commissioner Blanco's notes, and there's a lot of numbers there. I think the numbers correspond to buckets. Perhaps
Okay, I'll
could
go-
you highlight some
I'll
of
go
those?
through my,
Please, go through your bucket
I'll
list.
go through my bucket list. Not the real bucket list. I'm not doing that one. The first area of work, the first bucket of work, I would consider reviewing all the census data that's now available, and doing an analysis of where the growth is, where there's the loss, what those populations look like, demographically, ethnically, racially, potentially linguistically. So that's one area of work. Second, which I'm going to add because it came up, I think there was consensus, it's preparing us with our toolkit for going out to the input hearings. In other words, really helping us prepare for what kind of input we want around counties, communities of interest, neighborhoods, just work. I don't think that's a big area, but I don't want to skip it, because it was mentioned. Third, working with the technical consultant to take all the information from the public input meetings, including maps that people may have presented to us, and coming to us with with a proposal for, given the demographic census analysis they've done. Here's a first round presentation of what it could look like to adjust the population and take into account the criteria that are listed in the Voters First Act. Then working with us, back and forth to produce one set of maps. That's the first one that goes out, the second one that goes out, and the third one that goes out. And then the final report that needs to be submitted along with the maps for certification.
Okay.
And probably the certification materials themselves.
Yeah. Okay. So I'm going to, and that was roughly in sort of chronological order?
Yes, yes,
okay.
yes.
So I'm going to suggest some amendments, and just in terms of the chronology, or where they might fall in the chronology. So I did mention earlier some research on, legal research on, again, gray areas, maybe definitions if we need to. There's some questions about definitions within the Act itself, but that's a broader set of questions. But just some research on some gray areas for under the Voting Rights Act. Now, I would put that in stage one, or that early stage as well. And then I think what might have been your third bucket, I guess.
Working with the technical expert?
So we're still envisioning hiring some capacity to look at the quantitative areas where Voting Rights Act compliance requires it. So it's racially polarized voting and maybe historical data.
Yeah.
And again, I think we should be thinking now about how we're putting that description together, but I certainly want to, once we've got someone on board, work with the voting rights attorney on that hire or that contract. But I think that has to be embedded in the third bucket, which is sort of...
I would say consultants.
Right. So that it includes the line-drawn consultant as well as the other quantitative or statistical consultants. So all of them are working together in terms of some of the districts. So those would be my two major amendments there.
Okay.
In terms of, if you're going chronologically.
Right.
If I can ask you a question, particularly with respect to the preliminary review of the census data and where the growth and loss is that something that the technical consultant could do first and then work with the lawyers on, rather than having the lawyers undertake that work as part of this budget?
I would agree. I also had a question for you, Mr. Miller. I would imagine you, as our chief counsel, might be involved in some of the general legal research in order to, again, reduce the the cost of our outside counsel. So I wonder if you had a thought on your role in all of this in terms of helping us contain costs and utilize you and our outside counsel as a team most effectively.
Yes, and what I say is that this stage is the most important in terms of managing those costs, is defining the scope of work and the budget and the expectations at the outset, and then managing against that along the way. I think it, as you were saying, Commissioner Dye, it's perhaps problematic for us to budget for the firm how it would use its time in each of these buckets. But I think it's very worthwhile for us to have a clear idea of the areas, and this is something we could give them prior to Thursday to help them refine their thinking.
Yeah, and in fact, they may disagree with us. They may have come
That's
up
right.
with something we haven't thought of. And you know, I like the idea of asking it in the context of their work plan and how they would work with you and the commission to, again, minimize our costs and maximize the value that they're giving to us as special experts. You know, because they should have a sense of, no, you shouldn't be using me for that. You should use a technical consultant for that, or the commission needs to discuss this first, you know, and submit something to me. I mean, or yes, and I will be on my BlackBerry for 6 hours out of that 8-hour meeting. I mean, really, I would imagine we want to pick a firm that's going to work in partnership with us to get a good result for a good value for the state of California. So, you know, we need to have that conversation. So, I mean, when I'm, you know, asked by a client to put a proposal forth, you know, I tell them, this is how I would do it. This is my approach. You know, I'm going to use your staff to do this part because you don't need my time. And I'm going to go away and think about this piece of it, right? So I would hope that they would have that. They must have that already to have even come up with a proposal, that they have, like I said, implicit assumptions that they're making. We just need to understand what they are and see if we agree with them.
I think they probably need to define them further than from what is represented in what we received. Obviously, they've done some thinking about it, but I suspect they're a little bit where we are. You know, I think we have enough that I would propose, if the commission agrees, to have a conversation with each of them about this subject and ask them to scope out in a more specific way than they have where they would be deploying their time and where they feel they could add the most value. And I think we would expect different answers, and it might not line up with this conversation exactly, but that's a useful input.
Yeah, I mean, there's a reason why one firm came up with, you know, $20,000 a month, and someone else came up with, you know, 88 hours a month. I mean, there are assumptions that they've made, and so we just need to understand, like, how they think they're going to be spending their time.
The other thing, and I apologize for the obvious, but sometimes it gets lost, is we're comparing such very different animals in this exercise with essentially solo practitioners in Washington, D.C., and large firms here, and on a per-hour basis, except for Munger, they're going to be significantly more. Then again, you are buying a much different package. I mean, just by way of example, we had a request for information that specified that one of the criteria is to be available Thursday to meet with us in person. And both of those are phoning in. I'd be surprised if, you know, we didn't encounter that phenomena again with those people, and this arguably is the single most important meeting for either of them in anything that might follow. So it makes the comparison challenging, and it's not a heads-to-head situation.
Yeah, and I think that's the reason the capacity question and availability question is going to be really key. And coming up with an hourly rate, like I said, it's a bit of it's really an immaterial fact, because a large firm, you're going to have an associate working on things a lot of the time. In a solo practitioner situation, you're probably going to have an overpaid person working on things a lot of the time, but that might save you time. So in the end, what we care about is the total number, and we just want to understand what their approach is, and therefore what that total number is going to look like at the end of the day.
It would be helpful if we could revisit one more time, perhaps, meeting attendance. Is it the sense of the commission that you would have them just at the pre-clearance districts in the map drawing stage? I'll call those the on-the-road meetings.
I envision a couple others. I was
Well, you mentioned the statewide.
statewide ones. I think those are going to be very critical. And I'm not sure how many we're doing. At least one, I would presume, maybe two.
And I think that, there's a couple of areas, Los Angeles being an obvious one, but a couple of areas of the state where there's going to be difficulties because the intermixing of the ethnicity, perhaps the loss of seats, and so forth and so on, where I think we have the biggest opportunity for contentiousness. I think it might be useful to have them up here at those meetings as well. Just be around. Some other ones may not be as important, but I think places where we have a real potential for conflict over that. Even if they just heard the testimony, it might be the right place to have them.
Well, and I think we're kind of back to the issue of giving the attorney time to study whatever's submitted, especially if they get a whole state map all at once. You probably don't want a real-time response. The way that we organize a statewide input meeting might be you submit the maps 5 days in advance or something like that. And then we have our attorney there, and you can have a discussion, and the groups are in the room, and it can be interactive, and we can make sure we understand what the concerns are, which may or may not correspond exactly to where the lines are, so that we can address the concern and not get caught up with specific lines. And we can structure it so that it would be very valuable, because I think a number of the applicants that we chose to move forward talked about that kind of collaborative approach.
It seems to me like a lot of this that they're the expert, and we're expecting them and asking them to tell us if that's fruitful for them or not, if that's the best way for them to do business in the Citizens Commission and provide a legal opinion or not. So it just keeps taking me back to the same broken record, which is, to me, it seems like if we can just come up with a fair hours estimate for what we expect and come up with a per hour cost for that, then we can have some kind of not to exceed number with, some kind of not to exceed number. And
well, we have a
go
not
from
to
there.
exceed number. And I would
What's that?
I would posit it's $150,000, as we've been talking about, and I would posit, Commissioner Ward, that coming up with a number of hours and an hourly rate is exactly telling them what to do. If I were a consultant, I would be horribly offended by that. If I'm asked to put a proposal together, I will tell you, this is phase 1 of work, this is phase 2, this is phase 3, this is how I'm going to contribute, and here's what my hourly rate is, and this is what I think the total is going to be, and there may be some deviation along the way. But again, if you're going to ask me what my opinion is as an expert, I can tell you how many hours. Don't tell me how many hours it's going to take me, right? With the exception of attending meetings, which will be out of their control. But to a large degree, I would imagine if we're asking them to do certain legal research, they should be able to estimate that on their own.
So a couple of points. I ran over here in the rain.
No. Mr. Claypool, please.
First of all, our BCP isn't submitted yet. Our letter to request the additional $1 million that has been allocated in this year's budget is in, but our budget change proposal for next year isn't in. So we have the flexibility to increase this amount, but we need to know what that amount is very quickly. You need to know that. So we're not locked in yet. But we're, as I believe someone said the other day, I think it was Commissioner Baraba, we are at the 11th hour, 59th minute, so we need to know. The second thing, staff's working to put your calendar together, and I don't want to steal the thunder from the outreach and technical committees. However, we are looking at 20 meetings before you actually come out with your with your draft maps, and an additional 18 meetings after that. And then talking about another 20 meetings before, one of which will be what Commissioner Anchetta said was a big meeting to bring in the organized groups. And then an additional 18 meetings after that. And then beyond that, an additional 10 meetings where we had budgeted you would meet just with your line drawer when you amalgamated this information to be able to go through what you wish that person to do and what that person has done for you.
Right.
And finally, we're looking at an additional, I'm trying to remember how many, 10 to 12 meetings, business meetings, that we're trying to combine because clearly your months are disappearing. Right. So we're trying to combine them as well as we can. What we're hoping for, and I hope the CSU Northridge forgives me for saying this ahead of time, that CS Northridge would host us for a big meeting in LA to bring together the organized groups, and that would give you an opportunity to spend even more time in Los Angeles than you're already going to spend. Most of your meetings, the vast majority of, or the largest percentage of your meetings, will be in the Los Angeles area and the Inland Empire, because that's where the tremendous amount of growth has occurred. So we're trying to put together a schedule that gives you some breaks in between and then has a natural travel path to it. But your path is going to lead you south a lot.
I think we should just purchase an RV.
I was going to say we should have a tour bus and just truck it around.
I told you when I came aboard on this, I thought that you were going to give me my wish. I'd always wanted to buy a bus. But at any rate, we are looking at a very large path. Another thing that we'll need to, as a commission, to understand is our 14-day noticing period and how that's going to affect us in putting our maps out. So as we put them out, what we thought was that you would have the opportunity at the end of May to look at all the information and talk with your line drawer, take a break around the Memorial Day weekend, then come back the following week and look at what has been done, and then agree that those are once you've tweaked them, those are your draft maps. Now you have a 14-day period where they have to be displayed to the public. And so during that 14 days, you will once again be going to input hearings and taking input. And then at the end of that 14 days, we're looking at you now having to meet with your line drawer again to take in that vast amount of information. And then we have another 14 days. If we do it in that order, you'll have 4 14-day periods in which to kind of get things done and have time in between. So that's the timeline. I suspect that you won't be with your line drawer to the extent that you will be drawing lines as much as you will be with your line drawer and your VRA attorney to give them your direction and then go back onto the input road and then come back and see that your direction has been followed. So that's it.
Well, thank you. That's helpful information to know. Now, just on when is this on the agenda to actually go for the staff to present this and the commission to actually sort of discuss that? Is it on Friday or Saturday?
So certainly, the technical committee and the outreach advisory committees will be
Right.
involved with reviewing this, and then I believe that we had intended on talking about this on Friday. It really has to be Friday because Saturday will be taken up, so it will be an agenda item, and we're trying to get that out. Clearly, we want to get it out to you ahead of time, so that you can see the progression.
Wonderful.
Good. That's very helpful. Okay. So back to buckets then. Do we have our buckets
I think so.
lined up at this point?
Yeah. And, it looks like we're all coming to sort of a similar thinking about how this flows together. It's very similar to our discussion.
Okay.
Yeah, I mean, the main thing is I just want you guys to know what the buckets are and then make sure that those buckets are addressed, in the interviews and so that we understand how they came up with their estimates.
And I do understand, I think, obviously Commissioner Ward is raising a very strong concern regarding just trying to get a handle on the dollars and how many hours. But I think it is challenging, other than broad ranges of tasks that need to get done, to get that specific. And I think I feel comfortable with the not to exceed number being put out there, and we have a sense of the range of hours. And I think that's probably what we should be expecting. That's kind of what we're going to get per hour. But I think it's difficult. We should just ask. I think on Thursday, what your estimate, roughly what your estimate of hours would be, and then kind of look at that and say, okay, that seems to make sense, or it's well within, or if it exceeds the not to exceed, then we have a problem. But I think if that's seems to
It's all I've been driving for. It's just a not to exceed number. You mentioned 150. I had 200 based off of Stan's input, and I just was trying to understand where we were getting that number from. That's why I was discussing hours. Is understanding that, okay, we've pulled this figure. How are we justifying that figure? And so what is it 200,000 or is it 150,000?
150 because that's what we've budgeted, so it's based on our budget.
Well, we have the opportunity to amend that,
increase.
correct?
I would suggest that we ask the part of what goes out in the materials that Mr. Miller's going to send out when he asks the applicants to address these 5 points or whatever, I lost count, that he also asks them for hours. So we don't just do it in the meeting. They actually, that's part of what they come back to us with. It sort of goes back to Commissioner Forbes' idea that in a sense this is not just an interview, it's also a presentation of sort of what you are saying you can do for us, and then we have questions also, but it's a blend of both.
Well, I feel comfortable I think that's fine. I think we should give, to the extent we're giving them advance notice on the basic categories, the buckets as we're calling them, that we can ask. I think it's fine to ask them rough estimates, general estimates on what you think the time required for each of these broad areas would be. And again, within the overall guideline that we said, well, 150 is all we've got budgeted for right now. We may want to decide whether if we want to go up at all, but I certainly don't want to do that without the budget committee thinking about this.
Yeah, I mean, I think that if you look at all the proposals that were submitted, you know, again, with the proviso that it wasn't clear if all the buckets were included in some of the proposals, I mean, I think you'll be comfortably within that. And as Stan pointed out, it's a lot of hours that you're talking about, unless someone's charging you
even at
$800
$500 an hour.
Yeah, that's a lot of time.
It's a fair number of hours. You know,
And we are supposed to hire experts, so it shouldn't take them as long as someone who's not an expert, right? I mean, that's the reason you're willing to. I mean, I always tell my clients, you know, you shouldn't worry about my hourly rate, because at the end you should care about how much it costs you. And if you're happy that I can, you know, deliver this value for $50,000, why do you care how many hours I work on it? Yeah. So I don't actually think the number of hours is important as long as we get the results that we want. You know.
Because if you define hours, they will be filled.
Exactly. So I wouldn't focus on that again. We're trying to look at what the budget is and what is the value added they can deliver. And I think, I think this question is back again to Mr. Miller in terms of your role in managing outside counsel moving forward. I mean, I would hope that you would be a VRA expert by the end of this process. So I would think that, there are a lot of things that you might look at and say, that doesn't make as much sense to have outside counsel do this, or I'd like to do this piece and have them review it. I mean, I would hope that there'd be plenty of flexibility for you.
That's correct.
That's right.
I still keep coming back, however, to the phantom meetings. I'm thinking, for example, of a lawyer coming out from D.C. Each meeting is really a 3-day trip.
Right.
I don't know how they've factored those in, and of course we'll have to come back to their availability to do that. But I just don't come away with a clear view of the number of, I'll call them trips or meetings that you'd be expecting them to participate in.
That's a good point.
Yeah. Well, let's start. I think I agree with several folks who have mentioned that the Section 5 jurisdictions probably are important ones for the attorney to be at. So that there's 4 counties.
Although we're not going to all
Four,
four
which ones, so
separately.
we're kind of doing
Not a Monterey one.
Monterey.
That definitely a Monterey.
We're doing Monterey, and then did we have one other one? Kings? Is Kings in there?
Kings is next to Monterey, so I'm not sure if Kings falls
Go
within that
ahead.
same
Yeah,
region.
let's
Oh,
not speculate.
Oh, okay, so right now we have Monterey, Yuba, Kings, and I believe Merced.
Said,
And in your first 4 input meetings will be in Yuba, Monterey, Merced. So you'll hit all 4 of them to start with, and then you will hit 3 of the 4 again in the second round.
Okay.
So are they on a single trip, though? Thinking of someone coming in from the East Coast.
Two of the first 3 are on a single trip. Yes, and again, we can rearrange them. We can rearrange them to put them on a single trip if we needed to. That's
So
as long as you don't mind driving a little
so
further.
437, 7 section 5
Bus.
meetings.
Yes, and we can make it 8.
Section 5
We
meetings.
we just don't hit Yuba twice.
Okay, all right.
And Yuba's the smallest one.
Yeah.
I think one meeting is long. And Yuba's covering is that covering the Sacramento region as well, or is it just Yuba?
That was actually just Yuba County. And now I should ask you, our meeting is actually we're planning it in Yuba City, which isn't in Yuba County. It's across the river from it, but it had the facility. If we want to be in Yuba County itself, they're sister cities. Yeah, Marysville is Yuba County. Then it's either that or I believe we might know Oroville's Butte. We'd have to go into Yuba City and try to find a facility, and we were just having difficulty doing that.
Let's not get, for
Okay.
this purposes, let's just say that we will have, the attorney will be expected to attend 7, section 5?
No,
I don't,
no,
right? That's
no.
that's what we're saying, so let's,
No, we're not. We're
No,
talking about
no.
a trip that will hit all of them.
But I don't think it's 7 meetings. I wouldn't think they're necessary to go to 7 meetings.
Well, and I have to question whether we physically need them there, because they're going to have transcripts, there'll be video recordings. I mean, do we physically need them there?
Well, let's talk about that. So we have, you did say 4 and then going back to 3.
Right?
That
It was
doesn't mean they're
physically
all day, but there's
7 input meetings.
7 input meetings in section 7, section 5 input meetings.
Let me clarify that. 6 because only Hanford was in Kings, and I think about it. We were going to go close in it to another one. So only 6.
Okay.
All 4 in the first round and 2 in the second.
Okay.
And
Focus two.
keeping in mind that we're going to have a technical consultant that will be summarizing the input for all these meetings.
So let's discuss that. So there was some feeling that those were for those who thought that because it was section 5, there was a particular need, and Mr. Miller, I include you in this. What makes them different than the other ones?
Well, I think the thing that makes them different, that doesn't necessarily mean that the lawyer has to be there, is
I
that
mean for lawyer attendance.
yeah, well, is that they will get more attention. There'll be more scrutiny. They're not necessarily the highest litigation risks, because I don't know how much the lines are moving there, but they get more focus because
One of them
their
has, I
staffs.
think, in the stuff that we've seen, has a lot of lines moving. One of them.
Yeah, and so this is another one. That would be a great question to ask in the interview is, we have these 6 meetings. Do you think you need to be there in person?
That's why I thought we've landed on this, twice now is that we were, even your input was that here's our do not to exceed, here's our scope of work. What's your proposal? And see what we get out of that. Some might feel they need to be there. I'd like to know why. Some might feel they don't. Okay. But I just don't, I just don't know how we need to make that decision for.
I agree. I think you're right. Sorry. I think you're right. I think the question to them is, these are 4 counties that have Section 5 issues. Mm-hmm. Do you think it's advantageous for you to be there in order to be our counsel, our VGA counsel, VRA counsel? And they may say, given the fact you can look at video, you can got transcripts and so forth and so on, it's useful for you to be there. If you think it's useful for you to be there, great. But on the other hand, given this is how much money we have, maybe in your judgment, that's not the best use of the money and your time.
So I think what we do need to provide, and what Mr. Miller needs to have a clearer handle on, is just this information so that we can ask these questions and give them the parameters so they can figure out how to provide the best value for us.
And the same argument, I made the comment earlier about areas like Los Angeles where there has potential for real conflict. Ask them the same question. Here's what's been happening in Los Angeles. Here are some of the issues in Los Angeles. Should you be there at those meetings, or is it? That's it.
Yeah, and I don't have any. There's no question in my mind that when MALDEF and any other organization saying these are our maps, we'll need to have the VRA attorney there. So that kind of goes without saying, but I just wanted to say that.
Well, you're going to get that from them in Section 5 and in LA as well, not just in statewide.
Oh, I mean, in terms of their presenting
Yeah.
there as well.
Yeah.
Okay, that's interesting. Well, how do you know that?
I don't know that, but if there's areas, I don't. But if you have areas where there's a population shift and where there's conflicts,
Right.
and there's
That's a lot of
and
areas.
there's a lot. They are probably going to have opinions about what should happen
Right.
with the assembly and
Right.
Senate districts and congressional districts in the LA region. I don't see
Sure,
why
but
we
wouldn't that happen when they're presenting a statewide map?
Yeah.
Yes, yeah. I'm just saying that they're going to have very
Ideas
concrete
about every-
ideas in those
in a
other
bunch
ones
of
as
different
well.
areas,
I mean,
yeah.
it may not be a map, but they're going to have things that they propose about those areas.
The problem I have with that is that opens up a lot of meetings.
Yeah, no, I'm not saying we need them. I'm just saying that that's
Yeah.
not the only place where we'll get heavy sort of.
Right.
know,
I think the problem I have, though, is if we follow that logic, that it opens up a good half of the state, actually.
I think it's the statewide meeting, I think is what it is.
That's where I think it should be focused on.
After they've submitted the maps and after
Right.
attorneys had some time to study them.
Yeah.
So anyway, I think if we give, the candidates these kind of parameters and just let them know kind of what the schedule's shaping up to be, that will give them enough information on what we anticipate to happen at these meetings, then they can assess and tell us, yes, we think we need to be there, or no, we think reviewing the transcripts will be fine, or we think discussing it with the technical line drawing consultant will be fine.
Yeah, and there will, as we've mentioned before, there will be key business meetings where that's what we're going to, that's pretty much it. That's where we're starting to get into the nitty-gritty, and that they should be there.
Enough?
That doesn't help you at all, does it?
Well,
It does. It is helpful. It's a different approach, but actually, I think it's the right approach to give them a general description, and as you say, invite their expertise as to where they can best lend expertise. And I think that is a superior approach than to try and be overly specific as to the expectations. So I think most of this will be done in conversation, letting them report back to the commission on Thursday with their thoughts about how to do the work.
right. And I think it's okay at this point because we're sort of meeting in advance of the full commission, and this is clearly a set of issues that we have to discuss as a full commission to figure out this calendaring and the whole intersection of the various consultants. So I don't feel bad that we're not that specific today because, again, I don't want to sort of act in the place of the full commission in terms of trying to map out the clearest process. So I'm happy to sort of move forward with what we've got today, and then just again, and then we flagged some important questions that I think are very appropriate for discussion on Friday.
I just wanted to also say, amongst those last 18 meetings,
Just the last 18.
just the last 18, we're actually only scheduling 15 of them and holding 3 in kind of in advance to give a 14-day notice on for those areas that just become, crucially important.
Sure.
So when you see the TVDs, it's not anywhere in the state.
I'm looking forward to seeing that schedule. I've cleared my calendar as much as possible, but I'm curious. Yeah. But we all signed up for this. Let's not forget that.
Not to make this even worse, but we still have the open question about whether everybody attends, all commissioners attend all meetings, correct?
Yeah.
I think we agreed that we would try, but understand that it's just not going to be physically possible.
Yeah. Well, and I would simply want to table that for.
Yeah, no,
Yeah.
so, yeah,
Yeah.
so but we haven't come to
No.
No.
either
no,
one way or another.
No.
Okay.
No.
I'm just trying to clarify if we have or haven't.
Well, let's save it for the full commission because it's fun to talk about this stuff, obviously. Just come to how our lives are now changing because of the commission, but again, we signed up for it.
That's right.
I don't have really great notes, so I thought it might be good to summarize. And again, I don't have the best notes. Maybe I'll ask again, somewhat staff to summarize, perhaps, and then open up for public comment so that we're clear on how we're proceeding. Does staff have that enough of at least a skeleton in terms of what we're doing?
Let me try. I'm going to call the first bucket fundamental research and advice to the Commission on gray and ambiguous areas that must be addressed in any mapping process. 2 would be consult with the line drawing consultant regarding growth areas and loss areas. But I see the lawyers here as really the receiver of the information rather than the analysts of the information. Some advice, and I'm assuming this is a very discrete number of hours, like 5 or 10, around preparation for input meetings. Then the big chunk here, of course, is work with a technical consultant on an ongoing basis to receive input from input meetings, to consult on draft and final maps. And that's really where probably the chunk of the work goes. Attendance at statewide map drawing session and such other business and input meetings as recommended by the lawyers to the Commission. And then finally, preparation of the final report.
Okay. Anything else the commissioners wanted to add to that?
I would still like to leave us the ability in that last bullet to us to tell them that there might be something we want them at specifically, so that it's not just them saying where they think they're necessarily. But there might be times when we want to say to them, you really need to come to this business meeting.
This wouldn't preclude that, but rather their estimate would be based on their view of the world, with the understanding that you could request them to be there.
We'd had some conversation about racial polarization studies and things like that. Is that something that we want to consider with that?
Was that mentioned in there, or was it embedded in it?
Well,
It's sort of working with the consultants.
it seems to me those are the issues that fall out during that work. I can call them out specifically, but I don't know. I really don't know. Are they delivering a study to the Commission on that subject matter, or is that something that is baked into the product of the maps with the line drawers?
I think it may be more of the latter, although I think some sort of report from a consultant on sort of the lay of the land. And I think we have to have some discussion about that in the technical committee as well, in terms of what we're going to be asking a statistical consultant to do for us. But I think as long as it's embedded into the basic category that the attorney will be working with whatever consultants are looking at those questions.
I guess what I had in mind was when a map is presented that requires legal color commentary, that's the place the Commission would get it, is in connection with a discussion and presentation of a map where racial polarization is at issue, as opposed to a separate deliverable. Now, I'm not asserting it must be that way. That was just my sense of the work.
I think that's absolutely right. I mean, this is why the one application struck me, because if we're asking them to do this analysis with us after looking at the data and the population shifts, and then doing a legal analysis and to work with the technical consultants, that is going to include, part of what we want to know when working with them is, okay, you say there's been a population shift here, and this is now this county used to be 30% Asian. Now it's 56% Asian, and but we need to look at. We're probably going to, before we decide we're going to draw this, we need to look at this from do a legal analysis of the racially polarized voting in that area. So I consider that to be part of the analysis with the information and all that they do with the consultant. I think it's true we'll need experts to do the statistical regression work, but then the lawyer has to incorporate that in the legal analysis for us. So I think that's got to be part of the core competency.
The legal analysis of racially polarized
the legal
vote.
analysis has to be the racial polarization analysis. I don't see how it can be a one-off. Maybe after it's explained to me, I can't see it. But right now, I'm considering it to be part of the analysis and should be considered there for pricing and for costs and all of that.
That's right.
So I think the way that Maria had, Commissioner Blanco had stated this before was ongoing work with the technical line drawing consultant and other consultants as needed, because there might be other experts that we have to involve in this, but that would be providing input for legal analysis.
Okay. Any additional commissioner comments before I open it up for public comment?
I was just going to ask, Dan, when did you need any changes to that letter to you? So if we wanted to increase the amount we're asking, when do you need to have that by?
Well, I talked with finance last week about actually submitting it yesterday. But then yesterday we finally got our budget officer on board, and she looked at my work, and so she spent the last couple of days kind of unraveling a couple of things, very minor items. But
I'm sure.
But she is going through it. So we had hoped to get that out by. Actually, she's going to come and give the presentation on Thursday. So we were hoping to try to get it out by Thursday or Friday. But with the commission in town, it doesn't look like it's going to actually, because of all the demands, get out that quickly. Having said that, so I would say that we have time to discuss this in open session and come to a conclusion, because it really is going to require you to say, up the budget, so that when I go to finance, I can say it wasn't my fault; it was their fault.
Commissioner Dye is here. Commissioner Ward is here.
Yeah,
our
right,
budget representatives.
Could I recommend that we just very briefly consider making a recommendation of increasing that at this point?
Can we do that?
Well, based on what, though?
Well, based on the full scope of what we've just determined. This is a different scope than what we'd put out. That's why our bids came back, some including some things, some not. Meetings included, meetings not, that kind of thing. Now that we have a kind of a tangible idea of what it is, roadmap of where we're going, and what we expect out of the VRA, looks like, and now after receiving the bids and seeing a vast idea of what they consider is going to be necessary to meet those needs, it seems like upping that limit to $200,000 as a not to exceed seems, in my opinion, appropriate. And it seems like we might want to come to a recommendation if that is something we see necessary for the open commission, instead of just discussing it
I think it's premature. I think you're negotiating with yourself. If we say we have $150,000, and we say here's the scope of work, and they can say yes, or they can say no. If they say no, then come Thursday night, we're in a position to make exactly the same recommendation.
Yeah.
So
With more information.
With more information. I mean, but if they'll say we can do that scope of work for $150,000, we can do that. Then